Good afternoon. My name is Tim Lynch. I'm your host of Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. Our number here is 617-708-3290. Our guest today is Vicky Henry of GLAAD, and we have an exciting program. We're going to go over the two recent Supreme Court cases dealing with gay marriage. Vicky, how are you?
I'm good, thank you.
So you're with GLAAD, and we've had many folks from GLAAD on the show, but why don't you remind our viewers exactly who is GLAAD and what do they do?
Sure. We are gay and lesbian advocates and defenders, and we're basically the leading legal organization focusing on rights in New England, trying to get rid of discrimination based on sexual orientation, gender identity expression, and HIV status.
And one of the cases you worked on recently was a DOMA case here in the First Circuit. First Circuit is the federal court dealing with, amongst other things, the Boston area.
Yes.
So, but that case didn't get appealed to the Supreme Court. There was another case in the Second Circuit that did.
Well, actually, the Gill case that you're talking about that was here in the First Circuit and was decided last May, and we did get a ruling that DOMA is unconstitutional. It is up at the Supreme Court. It's being held while we wait, and the Supreme Court decided to hear the case Windsor versus United States of America, but the Supreme Court's holding Gill and a couple of other DOMA challenges.
Oh, okay. So why don't we start off by first saying, what is DOMA?
Okay. DOMA is a federal statute. There are actually two parts to it, but there's the part that's at issue in the court cases defines marriage for all federal purposes, and it basically says marriage is one man and one woman. So what DOMA does in terms of Massachusetts is we have one class of people in Massachusetts. We just have married couples. We don't have a special license. There's actually no such thing as same-sex marriage. There's not a lavender marriage license or a rainbow marriage license. We just have marriage. But the federal government just erases the marriages of couples who are of the same sex, and it won't recognize them for any purpose.
So, and thus the DOMA statute.
That's right.
And that was passed in 1996?
That's right, yes.
Okay. And so the good folks at GLAAD challenged this law, and you had a number of interesting plaintiffs too. I think some interesting stories there.
We did. We had I think 17 plaintiffs. We had some federal employees who just wanted to be able to get the same employment benefits their colleagues could get, like health insurance or flexible spending account access. We also had retirees who wanted to be able to get the same Social Security benefits as other people. We had one couple that's married and they cannot take advantage of the spousal benefit, and we had two widowers. We also had some couples who have to pay more in taxes because the federal government does not recognize their marriage, so they can't file their taxes as married filing jointly or married filing separately. And we actually had a passport plaintiff because for a while you could not get a passport in your married name if you changed your name. That claim went away very quickly because when Senator Clinton became Secretary of State, she changed the passport regulations.
Oh, thank you. Thank you, Secretary Clinton, former Secretary Clinton.
That's right.
There you go. So okay, so these, for whatever reason, the federal government, for the first time, decides to come in and decide what the definition of marriage is.
That's right.
And I think historically it's important to note that when states were dealing with interracial marriages, and some states allowed interracial marriages and some states did not, did the federal government ever get involved in that?
No. For 220 plus years, the federal government had never defined marriage and had always left that to the states. So whatever the state's definitions were, that was our uniformity, was they took each state's definition and they didn't question it. And we actually have historically had big variations in marriage law across the states. People don't always remember that, but there were differences in interracial marriage. Some states allow first cousins to marry, other states don't. Common law marriage, of course, was a huge difference. Divorce and how one could divorce also was a huge difference. Age limits, I mean, very, very significant differences. And community property, I think, is interesting. Some states are community property states. California is a great example where everything that comes in during the time of the marriage belongs to both people equally. states adopted community property to attract women to move out west, basically. But it's very different from the way that we have property laws here in New England usually.
So basically different laws pertaining to divorce and things like that.
Right, right.
And for whatever reason, the federal government decides to get into the definition of marriage.
Right.
So on you go. You try the case before Judge Toro.
Yes, he had a hearing about the constitutionality of DOMA. We call it the Defense of Marriage Act, or DOMA.
And Judge Toro in the Federal District Court here in Massachusetts rules unconstitutional.
Right.
So then it's appealed to the First Circuit.
Yes.
And then while you're in the First Circuit, there's the Obama administration does some changes.
That's right, that's right. So it turned out that GLAD actually brought a second case, a second challenge to DOMA in Connecticut, which is part of the Second Circuit. That court covers Connecticut and New York, among other states. And the ACLU and a law firm called Paul Weiss brought a suit in challenging DOMA in New York. That case was called Windsor versus United States. So those two cases were filed on the same day and were actually on the same schedule, but the New York judge issued first. But both judges, at that point, the Obama administration had to decide how to defend those lawsuits, if at all. And the difference between the Second Circuit and the First Circuit was that there was no appeals court level ruling talking about how to handle discrimination based on sexual orientation. There was a decision here in the First Circuit that said just basic review, not a heightened, tougher look. They didn't have that in the Second Circuit. So for the first time, the president and the U.S. Attorney General had to make a decision. And when they looked at all the law and the way the Supreme Court has handled groups in the past that have historically been discriminated against, they said they thought this heightened scrutiny or tougher look applied, and that DOMA just did not pass muster. It did not survive that review. So they stopped defending, and once they stopped defending in Connecticut and New York, they stopped defending in all the cases.
Okay, and before I get into who did come in to defend, let's just back up a little bit. So you guys attacked DOMA under what's called the Equal Protection Clause of the 14th Amendment of the U.S. Constitution.
Right.
And basically what that says is you can't treat different sets of people differently.
Actually, let me go back. It's
Sure.
actually the Fifth Amendment for the constitutional scholars out there, because it's the federal government.
Oh, yeah, okay. Oh, that's right, you're right. Oh,
Yes.
you're right. Fifth Amendment, 14th Amendment applies it to the states, but you're right, Fifth Amendment, oh.
Yes, but it's equal protection. The idea is that the government should treat people the same if they're similarly situated.
And depending upon which groups you're talking about, the court, when it looks at these statutes, is going to take certain scrutiny.
Right.
And sometimes they take heightened scrutiny, particularly when it deals with race. You know, you're treating different racial groups differently.
Yes.
Then there's intermediate scrutiny, which I believe applies to gender.
Yes.
And, you know, if you treat the genders differently, the court's going to apply, you know, intermediate scrutiny. And then there's the lower scrutiny, which is basically there has to be a reasonable basis for the statute.
That's right. And we're not distinguishing between the strict scrutiny or the intermediate scrutiny. We're just saying more than this basic level of scrutiny. Whatever level it is, it's heightened. It's an extra look. It's not, can you come up with any conceivable basis to justify the statute? And with that heightened level of review, you're supposed to be looking only at the reasons Congress gave at the time, whereas under this basic level of review, if you can think of any reason, even if Congress didn't think of it in 1996, any reason to support the statute, then it would be constitutional.
So it's a very low standard.
Yes.
So there's an open question there. Is the Supreme Court's never decided that particular issue, which standard?
Right, they've always, in the cases in the past where they've looked at discrimination that involved sexual orientation, they've just said that the statutes involved, particularly was Amendment 2 in Colorado and then the sodomy laws, that the statutes really were just so wrong that they did not survive this lowest level of review. So statutes can be struck down on that lowest level of review, and that may be what happens here.
Okay, so it's fascinating how this goes. So so we now have two cases, one in the First Circuit, which was brought here in Boston. The other one in the Second Circuit, because it was brought in Connecticut. They're on the appellate level.
Right.
The statute, DOMA statute, was ruled unconstitutional in both cases on the lower level. So now we're in the appellate division, the First and Second Circuit appellate divisions. And the Obama administration decides that there's no way this statute is constitutional. So then the House comes in, the House of Representatives, because they passed a law way back when saying we can come in and defend a law if the President and Attorney General does not.
Right.
So here we go, and now you have the First and Second, and they rule that these laws are unconstitutional. And that brings us up to the recent Supreme Court case. In the Supreme Court case, they took the Second Circuit opinion, second case up, and they're putting the First Circuit case on hold.
Right.
Okay. So why don't we then, so now we know that, there's basically two things then I take it. There's what level of review that you're going to look at that, and then what are the arguments that are subject to that review?
Right.
So why does, we know what Justice Kagan said, which was very good when she quoted the House report saying that they were making a moral judgment on gay people, which is very unsettling, to say the least. But what are the arguments that they're making to justify this discrimination?
Sure. So one of the arguments was that the federal government gets to define the terms of in federal law, and that it's perfectly reasonable for them to do that, and that they want uniformity, that your benefits that you get from the federal government should not vary based on where you live. Now, of course, the problem with that is they didn't define marriage uniformly. I think if they had, you would have had states up in arms because they would have been trampling on everybody's rights. And so they've defined one aspect of marriage, and they've actually created a big disuniformity because they're disrespecting marriages now from 9 different states in the District of Columbia. And so they're actually kind of really saying in their brief, it was a little bit shocking to me, that they should treat all same-sex couples the same and all heterosexual couples the same. So because some same-sex couples in non-marriage states can't get benefits, then none of us should get benefits.
Wow, that's very confusing.
Well, with friends like that, we're in trouble.
Yeah, so that was that argument.
Yes. So another argument that they liked was caution.
What do they have to be cautious about?
Well, marriage is a very important social institution. Actually, I mean, that's part of why same-sex couples want to marry. It is an important social institution. And so they were saying, here's this important foundational institution, and is this a big change? We should hit the pause button and wait and see. We should just have the federal government make a change when one state makes a change. And so they were trying to say, we're being cautious with this important social institution. But the problem with that is DOMA was not cautious. DOMA was broad and sweeping and did not have any sort of sunset provision, like we're going to do this for 5 years and see where we are. It actually kind of put the federal government's thumb on the scale and launched all what are called mini DOMAs, or state-level Defense of Marriage Acts. So we argued, and was argued to the Supreme Court, that DOMA was not cautious.
Yeah, but it doesn't sound very cautious to me. But in